Here's the reality. If you've been charged with a federal crime, the odds are very high that there is going to be a sentencing hearing that's going to follow that federal charge. And you want to be thinking today about what steps can you take, what mitigation strategies can you use to position yourself for that sentencing hearing. One of the first decisions you're going to have to make is deciding whether you're going to accept a plea or whether you're going to proceed through a trial. And you definitely have to understand the opportunity costs that come with every decision. I did not understand those opportunity costs. I went to trial, a jury convicted me, and I was sentenced to 45 years in federal prison. And it's really that motivation that started me on this path of working to try and help people work towards the best possible outcome. And to work towards the best possible outcome, you've got to be the CEO of your life. And that means you've got to take steps to truly understand the process so that you can work most effectively with your defense attorney. And one of the steps that your defense attorney is going to take before he gets too far into the weeds is to try and get discovery from the prosecutors, right? Discovery is the evidence that the government has put together in order to bring the charge. So there's all kinds of evidence. It might start with an FBI agent or some other investigative agency looking at the criminal behavior, interviewing people, gathering bank records, understanding transactions, maybe even using telephonic recording. I mean, there's so many ways that investigators can gather evidence, but all of it gets put together: the documents, the emails, the recordings, the surveillance, the financial records, witness statements. And if they have a grand jury, it's the people that have gone to the grand jury. There's going to be transcripts. All of that becomes a voluminous and highly technical body of work, which is known as discovery. And your attorney's role is to obtain that discovery from the prosecutor and assess it. So they've got to determine, is this evidence sufficient to merit a conviction beyond a reasonable doubt? And you should know that a defense attorney, that's their job, is to make that assessment. And they are, a great defense attorney. If you ask a defense attorney, can they prove the case? The defense attorney should really walk you through the risks of going to trial. What matters is, what will the jury believe to be the case if you go to trial? Or what will the judge accept as being relevant? What will the judge accept as being admissible? What could be excluded? What might be suppressed, right? All of these are very complicated legal questions that a defense attorney will have to weigh. But you can definitely help your lawyer through this discovery process by understanding, the rules of discovery, also known as a Brady Act, based on a Supreme Court case. I think it was Brady versus Maryland, which forces the government to provide all of this evidence so that you can make an informed decision on whether to go to trial. But you will understand this context better than anyone, at least the roots of the evidence. You're going to be able to clearly understand the documents, the transactions, and the communications. You're going to be able to identify mistakes, missing context, or misinterpretations, and you'll be able to build that into your defense attorney's knowledge base. So you've got to be proactive, but you've also got to be extremely well organized. And you should only share and have these conversations with your defense attorney, because then, or your defense attorney's team, because then it becomes protected and it can't be shared with investigators or outsiders, and they can't be compelled to testify against you later. So you've got to be very methodical in this pathway, and you have to recognize it's to your detriment if you omit any information, right? If the government may present some type of information in the discovery that kind of throws you off, and a person may say, oh, well, they don't really have me because they don't have this. Your job is to help the defense attorney understand your thought process, because the prosecutor is trying to get a conviction. and they're going to fight for a conviction, and they will do anything possible to try and preserve evidence that they could use against you in a trial. So you want to understand everything, but if you spot a weakness, tell your attorney everything about why it's a weakness. Show the inconsistencies, the errors, but if it's an error that can later be corrected, don't leave your attorney in the dark of that, because if the prosecutors can correct the error and you know they can later, don't leave your attorney in the dark on that. The more your attorney knows, the more effective that attorney can be in advising you on whether it's in your best interest to go to trial or to pursue a plea agreement. So there's also this concept of exculpatory material or Brady material, which means the prosecutors even have to provide information that may mitigate your role in the offense or could help you in some kind of way. Sometimes they do, sometimes they don't. When they don't, if they get caught, it is considered a violation of the Brady material, and it can lead to a reversal of the conviction or even the case being thrown out in an egregious matter, right? Prosecutors are, I would just think, if you're being charged with a crime, think that the prosecutors are after a conviction, and they want to work toward the best strategy to get that conviction. You have to be thinking about everything you can do, including using experts like forensic accountants, data analysts, your own investigators that might challenge the government's interpretation of offense. All of those experts cost quite a bit of money, which you also have to be thinking about at the earliest stage of the journey. And then you want to be thinking about the strategic purposes of reviewing discovery, right? I would really encourage you to be very methodical. Keep a record. Make sure that the top of your record states this is for attorney-client use only. It is not to be used by anybody else, so it can't be gathered and used against you via a subpoena, which I discussed in an earlier video on our website. All of this information can be used to help you negotiate a more favorable plea. It can help you understand or how to make a more informed decision. It's super important for you to recognize every decision comes with opportunity costs. But if you don't understand how the system works, you could be positioning yourself for a much more severe sanction. I knew that I was guilty, but I went to trial because my lawyer had told me there's a big difference between an indictment and conviction, and with the right amount of money you could win. And being, living with the arrogance of a 20-year-old or 23-year-old, I decided to go to trial and force the government to prove beyond a reasonable doubt, not really understanding the depths of danger in which I was swimming. So I would encourage you, be very cautious. Keep good notes. Understand the financial costs of going through, of evaluating evidence and discovery. Your lawyer may be charging you, $2,000 an hour to listen to every phone call, to read every email, to go through everything. If you don't have a budget to proceed through a trial and to fund that litigation, then that is a data point that you've got to consider, because if you don't have the money, you don't want to go halfway into the war and realize you're out of capital, and then you're in a weaker position. Typically, the best time to get favorable treatment in a plea agreement is very early, even before discovery. So you want to work towards that effort as soon as you possibly can. And also make sure that you are not destroying evidence or doing anything that could later result in a charge such as an obstruction of justice charge. Communicate openly with your attorney. Develop your own mitigation strategy, a comprehensive mitigation strategy that will help you all the way through the journey. And as I say in all of the videos, be very cautious about hiring anybody who fancies themselves as a prison consultant. I am not a big fan of that entire sector. These are typically people who served a single year or something in one prison and they fancy themselves an expert, but have very limited depth and breadth of information. You are the CEO of your life. You can figure out what is the best steps. You can work closely with your attorney, and you can architect a very effective mitigation strategy that will help you make good decisions. Everything on Prison Professors is free. It's part of the 3 promises I always make. I'll never lie to you. I'll never ask you to do anything I didn't do, and I'll never charge you a penny. Make good decisions as you prepare. If you need to speak with somebody, I only recommend my friend Justin Paperny, who's the founder of White Collar Advice, and he is also the sponsor of our work. He is whitecollaradvice.com/nonprofit, and you can get there. So just please take your time, educate yourself, spend as much time as possible on prisonprofessors.org, and you will then get the position yourself to get the best result possible. My name is Michael Santos. I'm the founder of prisonprofessors.org, and I believe in you. So be cool.